Hi, it's Mansumkize, and today we're just going to be looking at what a guardian's fund is. And really, just to be quite blunt, if your client's funds end up in a guardian's fund, really it means something has gone wrong. Either there's no will. The point is there hasn't been a proper estate plan. But however, we do have the guardian's fund, which is almost like a safety net to take care of those benefits for beneficiaries. So the Guardians Fund was brought into being by Section 91 of the Administration of Estates Act 24 of 1913. Now, just to put things into perspective, I just wanted to, just go back in history. What was so fundamentally important at that time that, you needed a Guardians Fund? What sparked it? So I went into a bit of history around that time, although not the actual reason, but I thought maybe the context of war might have spurred on the Guardians Fund. So before the Guardians Fund was set up, South Africa was in a state of war. There were many wars, such as the First and the Second Anglo-Boer War, the Anglo-Zulu War, etc. But for our purposes, I think it's simply worthy to note that South Africa, as we know it today, was crippled by wars. The South African Wars were a series of wars that took place in the southern region of the African continent. The tensions amongst European colonial powers and increasing hostilities with indigenous Africans. A key contributor was the pursuit of commerce and resources, especially following the discoveries of diamonds and gold. And unfortunately, simply put, wars are nasty and inevitably result in the deaths of many men, thus leaving women and children destitute. So if you look at the time period, 1879 to 1915, the Guardians Fund was actually set up by the Act in 1913, and obviously with the wars going on, thousands of people died as a result of those wars, and obviously men being sent in the front lines. That actually, that part when they died, they obviously left their families destitute, and specifically at that time, you remember that a woman didn't have any rights in terms of being able to contract and all those sort of things. So. The husband had the marital power of a woman. So the time frame when those sort of things happened, and then the men died in those wars, though somebody had to manage the funds for the children and women. So therefore, the setting up of the Guardian Funds. Now, while the creation of the Guardians Fund might have not been a direct result of wars, but certainly wars didn't help in reducing orphans at the time. Now, fast forward to today. In terms of the Act, the fund, the Guardian Fund, is set up to look after minors, people with mental incapacity, unborn heirs, missing or absent persons, fideicommissums, etc. So that's the intention of the Guardian Fund. So to maybe perhaps understand a little bit better, I thought we'll just use an example. It's far easier. So I'm going to take an example, and we're going to keep the facts very straightforward. So we've got a mother, she's a single parent, and she has a daughter. The daughter is 13 years old, which means she's a minor. Now, mom works as a teacher at a public school, and so that's the employer here where she works. And as part of her employment, she contributes a portion of her funds or of her salary. The employer deducts a portion of her salary and pays it all over to the government employee pension fund. Now, this is during the time while she's working. Now, suppose an unfortunate event happens and mom is involved in a car accident and she passes away. Now, if benefits from the government employee pension fund are supposed to be payable to the minor down here, the only problem with that is that you can't pay benefits to a minor. Minors can't contract, etc. They don't have the capacity. So 99% of the times what the government employee pension fund will do is take those funds and pay them over to the Guardians Fund. Now, an important thing, which is why this happened, is that because the mom did not have a will. So there was no direction to say, that perhaps, she could have created a testamentary trust to say that the funds should be payable into that testamentary trust to look after the daughter. In the absence of a will, the government employee pension fund will just simply pay to the guardian's fund. Now, the guardian's fund, once the funds are sitting there, so let's assume, for example, that the payout was R1 million on the death of the mother. So that R1 million would pay from the government employee pension fund to the guardian fund. And then the guardian's fund will give access to these funds to the public investment corporation, who will then invest these funds accordingly, wherever they invest them according to the mandate of the guardian's fund. Now, this money obviously earns interest, and it changes. The last rate that I saw was 7.25%. So this 7.25% is interest earned on that R1 million that was paid over to the fund. Obviously, it's earned through the public investment corporation employing the capital. So now let's assume that the mother had a sister over here. So the sister will now look after the daughter. Let's just say that was the arrangement. So the sister takes over the 13-year-old and looks after her. Now, as she looks after her, she's obviously going to want to have some sort of access for the benefit of the daughter from the fund. So what she can ask for is an allowance from the fund. Now, this allowance could be used for a whole host of things. For example, it could pay for school fees for the daughter, and the nice thing is that the guardian's fund actually pays the school directly. It could be used for just general upkeep, pocket money, clothing, and etc. So how does the fund calculate what she has access to? By the way, the sister would have to make an application to the guardian's fund in order to have access to those to that allowance. And in order to do that, what Advocate Vuyani Lali was suggesting is that you have to get a social worker involved so in order to assess, what the child's needs are and so on. Because, she doesn't have a guardian now. In our example, we're assuming that the dad is no longer around. Let's just say that the dad deceased the mother. So what can she claim on behalf of the daughter? So now we know that we were sitting with R1 million at the outset. So in terms of the fund, there's certain rules. You can claim up to a maximum of 250,000 rands per annum for whatever purposes, school fees, as an allowance. So in our example, let's just assume, for example, that she claims the full 250 in order to look after the daughter. That means at the start, they will be left with 750,000 rands. Now, as I've mentioned earlier on, those funds are still, after withdrawing the 250,000 rands to look after the daughter, the 750,000 rand is still sitting with the fund, which grows at the 7.25% interest, as I mentioned. While I just pause here while I talk about the interest, the nice thing about the guardian's fund is that there's no extra admin costs and so on, unlike private funds. So everything is completely free, barring one or two exceptions, like, for example, the Master's Office commission on dividends in certain cases. But otherwise, the costs are very low. So the total interest that would have been earned, just assuming over a year period, would be 54,375. Now, so let's just say that 250 was taken out in year one. Now, in year two, what can be accessed in terms of the funds for allowance purposes? It is, again, by law, this maximum of 250,000 plus your interest, because now the interest is yours. You've earned that interest. So in the following year, the maximum allowable to be withdrawn for as an allowance is 304,375 rands. Now, obviously, you'll notice that obviously drawing at this rate, you might run short of funds very very quickly. But I just wanted to portray the maximum allowable, just to show you the effect how they calculate what is allowed. Obviously, you have to submit an application every time you do an allowance. In terms of what I've found is they can take up to 40 days to make payments. So they do try and make it as speedy as possible, though we've had some hiccups, of course. Now, just some other things just worth mentioning. Now, we know that in our example, the child is 13 years old. The allowance can be accessed before they get to age 18. From 18 onwards, an application again can be made to actually get the actual inheritance, whatever is left in the fund, after those withdrawals, in terms of allowing to be maintained over the years. If funds remain unclaimed for a period of 30 years, the unclaimed benefits are forfeited to SARS. And the other important thing is that the magistrates' courts have jurisdiction in the master's offices. And I think the better person to explain this is actually Advocate Vuyani Lali, who is working with the fund. So let's just take a listen.
The Guardians Fund office, if you pass on, because there's also a will aspect of it. For instance, if you do in your will, you say that you leave money to your children. Normally, 99% of the time, when they make mention of leaving money to your children, it goes to the Guardians Fund. In fact, in South Africa, we've got 6 Guardians Fund offices. Although in each and every province, there's a master's office. What happens with those Guardians Fund, maybe to name them just a few, it's Pretoria, Bloemfontein, Kimberley, Pietermaritzburg, Cape Town, and Grahamstown. So, but in order for our people to access the Guardians Fund, for instance, you'll talk about people, communities that are from Limpopo, communities that are from Mthatha, communities that are from Port Elizabeth. We normally say that Bloemfontein, yeah, there is an office in Bloemfontein. Oh, yes. But from the far areas, we would normally say that there was a bad decision which says that each and every master of the High Court is a service point. So which means then the task that we had embarked on was to go to each and every magistrate court to train staff in order for them to be able to assist not only with the Guardians Fund but also with their state.
So I think the Guardians Fund is a good initiative by the government, but however, I think it's there for the worst case scenario, instances where there's no will or maybe there's a minor beneficiary. There are better ways to plan for succession in terms of making sure that your beneficiaries are taken care of. For example, in the fund, once somebody hits the age of majority, they can just simply come in and claim the funds. And you might not have wanted that. It might be a hefty amount of money. And if a 20-year-old gets a hefty sum of money, they might not have the maturity to control it. Whereas if perhaps you've created a trust, testamentary trust, for argument's sake, you could put more measures in and say the cash lump sum can only be accessed perhaps after finishing a degree and after the person has reached the age of, say, 25 at least. So there's much more tailoring around creating your own trust, but of course they do come at a cost. And perhaps just another thing, perhaps something worthy to mention. I used the example of a teacher and linked it to the government employee pension fund on purpose because when you look at the private sector, there could be an instance where, take for example, insurance houses, where if there's a minor that has been chosen as a beneficiary, the actual insurance house have created their own trust as a guardian fund, where they can accept those funds and then look after that child in that way. And of course, they'll have their own trust deed in terms of how they manage those funds and so on and so forth. Now, of course, there's more to speak about the Guardians Fund, but we don't play in that space. Like I say, it's really a safety net for when everything else has gone wrong, that the government says, hey, listen, we've got the Guardian Fund. We can actually push the funds into that. By the way, the other thing that's a problem with the Guardians Fund is that unlike creating a testamentary trust where the trust can receive, for example, physical property, the Guardian Fund is sort of limited to receiving funds from pension funds, so cash in other words. So the scope of what you can actually capture by using the Guardian Fund is not great. By the way, I use the word use sparingly. You can't opt to choose to invest into a Guardian's Fund. It's really, like I say, a situation where there's been no will, there hasn't been any proper succession planning, and it really just catches all those situations. Just like how it started way back in the past when there was the days of wars and we were just really looking after orphans. So I hope you enjoyed this snapshot. But otherwise, the real first port of call is for us to make sure that, for example, clients have wills. Thank you.